Hi, my name is Jo Delaney. I'm the chair of Baker McKenzie's International Arbitration Practice in Asia. I would like to invite you to a webinar that we are holding in May on the future of disputes in the Asia Pacific region. In advance of the webinar, I wanted to highlight a few key developments and trends in the region. The number of international arbitrations continues to grow, not only in Asia, but globally, as indicated by the record number of cases recorded before the ICC, SIAC in Singapore, HKIC in Hong Kong, and the LCIA in London. A report recently released by AKICA indicates that arbitration is also thriving in Australia. In 2020, the Singapore Ministry of Law commissioned the Singapore International Dispute Resolution Academy to conduct a survey of international arbitration. It indicated that the most commonly selected seats for arbitration was London, Singapore, and Hong Kong, which is consistent with the record number of cases in the ICC that indicates that the most popular seat in Asia is Singapore. With the growing use of arbitration in the region, it's important that businesses are aware of the key developments. And I just wanted to mention three of those briefly. First, a number of jurisdictions have been amending their arbitration legislation. For example, in Japan and the Philippines, they are reviewing their arbitration legislation to reflect the 2006 amendments to the UNCITRAL Model Law. Singapore has also amended its International Arbitration Act. And in the South Pacific, with the assistance of the Asia Development Bank, more and more jurisdictions have been acceding to the New York Convention and also adopting or modernizing their arbitration legislation. Now, the New York Convention is applicable in Fiji, Tonga, Papua New Guinea, Palau, the Cook Islands, and the Marshall Islands. New modern arbitration legislation based on the UNCITRAL Model Law has been adopted in Fiji and soon in Tonga, and is being considered in Papua New Guinea and Timor-Leste. Second, many arbitral institutions are reviewing their arbitration rules. Most recently, AKICA adopted new arbitration rules, which take effect on the 1st of April 2021. The ICC adopted new rules, which took effect on the 1st of January 2021. And SIAC has announced that they are going to also revise their arbitration rules. Thirdly is the common use of virtual hearings since the impact of the COVID-19 pandemic. Arbitral institutions swiftly adapted to the challenges that many faced with the COVID-19 pandemic. And a number of arbitral institutions, including the ICC, SIAC, HKIC, and KCAB in Korea, were party to a joint statement to encourage parties to do what they could to adapt to the new challenges. Many of those institutions have also adopted guidelines or practice notes as to how to conduct virtual hearings in this new world. Most recently, the revision to the IBA rules on the taking of evidence in international arbitration expressly acknowledges that the tribunal can conduct hearings remotely rather than in person. So those are just a few of the key developments I wanted to mention. I will now hand over to my colleague Ashish Chugh from Singapore, who will give you a brief overview of some of the developments in Singapore.
Thanks, Jo. Hi, everyone. My name is Ashish Chugh from Baker McKenzie, Wong & Liao in Singapore. As Jo said, we look forward to seeing you at the upcoming live webinar session on the future of disputes in Asia Pacific in May. It has been a significant year for international arbitration in Singapore and the Asia Pacific region. In the live webinar session, we will deal with some of the significant developments in this area in the last 12 months, particularly from a Singapore perspective, which can be broadly categorized as follows: recent statistics in relation to international arbitration in the region, key legislative amendments relating to arbitration in Singapore in 2020, and broad takeaways from some of the more important arbitration cases that were decided last year. As Joe mentioned, we will discuss recent statistics in relation to international arbitration in the region. We will in particular discuss a recent survey commissioned by the Singapore Ministry of Law and conducted by the Singapore International Dispute Resolution Academy as to the most commonly selected seats for resolving disputes by arbitration, and the notable reasons why participants selected those specific seats. We will also discuss the significant increase in new cases filed, particularly with the SIAC and the ICC, despite the pandemic, travel restrictions, and the growing demand for virtual hearings. With respect to key legislative developments, we will examine the recent amendments to the International Arbitration Act in Singapore and its likely impact in strengthening the legal framework for international arbitration in this jurisdiction, particularly insofar as it seeks to address issues relating to the growing number of multi-party arbitrations. Finally, we will analyze some broad takeaways from important arbitration cases that were decided last year. This will include a number of issues, such as A, the Singapore court's recent interpretation of arbitration agreements and the legal consequences that arise from it. B, whether indemnity costs can be ordered where an application to set aside an arbitral award or to resist enforcement as to the same is unsuccessful. And C, the enforcement of confidentiality obligations in the context of investment treaty arbitrations seated in Singapore. To hear more about this update, please make sure you register and join us at the upcoming live webinar session in May. Thank you, and we hope to see you there. Back to you, Joe.
Thank you, Ashish. Whilst there have been many recent developments in the international arbitration space, it would be remiss to not mention the growth of mediation in the region. There have been two key drivers to this growth. First, the COVID-19 pandemic has encouraged parties to find alternative forums for resolving their disputes in a cost and timely efficient manner. And secondly, parties have realized that they can take advantage of mediation as an ADR tool with the support of an international convention, the Singapore Mediation Convention, which came into force in September 2020. The convention recognizes and enforces settlement agreements that have come out of mediations in jurisdictions that are party to the convention. And this is to facilitate the ease of enforcing those settlement agreements. So it's not surprising that we are seeing more and more mediations across the region. A number of jurisdictions are also amending legislation or adopting new court rules or guidelines to encourage parties to use mediation as an ADR tool. For example, we have seen changes in Japan, Malaysia, Thailand, and the Philippines to encourage parties to use mediation. In particular, in Japan, the Japanese International Mediation Center and the Singapore International Mediation Center have issued a joint protocol to encourage parties to use mediation. So we're highly likely to see more and more mediations across the region. So these are just a few of the key developments that have occurred and that are going to be relevant to the future of disputes in Asia. We hope you can join us in May to hear about more of these and other developments. Thank you.